Hello. Today we're going to talk about the Crime and Disorder Act that provides definition of antisocial behaviour, and then we're going to explore about antisocial behaviour with particular emphasis on auditing of police stations and small demonstrations. Our concern is abuse. Whether the police can abuse the ASBOs, effectively that's what they're known as, ASBOs, in order to stymie, stop or arrest people exercising freedom of expression. So let's start at the beginning with the first definition, 1998 Crime and Disorder Act, which defined antisocial behaviour as acting in a manner that caused or was likely to cause harassment, alarm or distress to one or more persons not of the same household. More recently, that definition has changed. There's another example here on this slide about playing loud music in the early hours of the morning, graffiti, offensive and threatening remarks, dumping rubbish, harassment and intimidation. The antisocial behaviour does not have to be a criminal offence. For example, neighbour disputes, what would be a private civil matter such as private nuisance could also escalate to where the police become involved, or the local authority becomes involved, or the housing association, and we end up with ASBOs being applied to one or more parties. So, next slide. Antisocial behaviour does not have to be defined criminal offence. For example, private nuisance disputes between neighbours is normally a civil matter, but could also be antisocial behaviour. Still working on the definition, we're coming up to a more recent definition. This is under the Anti-Social Behaviour Crime and Policing Act 2014. Now you'll notice it's under section 2.1. The meaning of antisocial behaviour is defined, but it's defined in relation to who can apply for injunctions and sanctions. The bit we're concerned with primarily is section 2.1a. The meaning of antisocial behaviour under section 2.1 is antisocial behaviour means conduct that has caused or is likely to cause harassment, alarm or distress to any person. The nuisance element under B relates specifically to residential premises, and the conduct capable of causing housing related nuisance also relates to that, and the people who have to apply for an injunction in that case will be the local authority under section 2.1b. So our primary concern under this lecture is section 2.1a. What I will say before we move on to the next slide is this: the definition, if you consider it carefully, is very wide, which is worrying. Conduct that has caused or is likely to cause harassment, alarm or distress to any person. Antisocial behaviour means conduct that has caused or is likely to cause harassment, alarm, or distress to any person. What does that mean when we say that conduct has caused? Well, we're talking about a past event. So something has occurred that could be reasonably defined as an act of antisocial behaviour. Or is likely to cause. You will note here I've put an example of a fortune teller, because the police officer in those circumstances, or the PCSO, is able to speculate to some extent on whether certain conduct is likely to cause. Now, what does that mean? Is it likely to cause harassment and alarm and distress to any members of the public if a auditor, police auditor, for example, was filming private registration plates, or was poking their camera into the windows, or was trespassing? The problem is it doesn't have to be a criminal offence. It could be a civil matter. So is that likely to cause? Would the court say that's not likely to cause harassment, alarm, or distress to any member of the public? Does any member of the public include civilians working for the police? I think so. I don't think it would include PCSOs or the police based on case law, but I think it certainly would include other members of the public. So even if it does include police staff, what does that mean? Does that mean they're the sole arbiters of what is likely to annoy them or cause them harassment, alarm, or distress? Well, the answer is no. We have to go further than that. And I want to now explore what is the core of what is antisocial behaviour, and whether a human right can be trumped by the statutory rights, such as in ASBOs. Next slide. Well, the Police Reform Act 2002 section 50 gives the constable in uniform a power to require someone's name and address if the person is acting in an antisocial manner. So if a police constable in uniform has reason to believe that person's conduct has caused or is likely to cause harassment, alarm, or distress to any person, he may require that person to give his name and address to the constable. Now, antisocial behaviour has the same meaning given to it as in the 2014 Act, which is conduct that has caused or is likely to cause harassment, alarm, or distress to any person. So that's the definition we're working on. New slide. So the key things we're going to need to take from this is, let's look at this slide here. Conduct that has caused or is likely to cause harassment, alarm, or distress to any person. What does that mean? How does this relate to your human right under the European Convention of Human Rights not to have your rights interfered with or prescribed by law unless it is necessary and proportionate and justifiable. There's an important case I've referenced there which we'll speak about in more detail in a later slide, and that's RV Bonus 2005, and that was in the Criminal Appeal Courts. What does this mean? Well, the Metropolitan Police Guidance, there are three main categories for antisocial behaviour, they say. Personal antisocial behaviour is where a person targets a specific individual or group. Nuisance antisocial behaviour is when a person causes trouble, annoyance or suffering to a community. And environmental antisocial behaviour, which is when a person's actions affect members of the public or public space or buildings. None of the Metropolitan Police Guidance examples refers to public photography. We again explored what antisocial behaviour is by looking at the Home Office publication entitled A Guide to Antisocial Behaviour Orders and Acceptable Behaviour. And this gave examples of antisocial behaviour, but the list isn't total. They referenced verbal abuse, criminal damage, vandalism, noise nuisance, writing, graffiti, engaging in threatening behaviour in large groups, racial abuse, smoking or drinking alcohol while underage, substance misuse, joyriding, begging, prostitution, curb crawling, throwing missiles, assaults and vehicle crime. Again, they don't mention public photography. Key case, which should be new to most of you, is RV Bonus. Now, this case is what we call a precedent. In other words, it influences all the courts below it. And this was a Court of Appeal case, so that means any Crown Court or any Magistrates Court is bound by it. And it says, it is possible that prohibitions sought will interfere with one or more of the offender's ECHR rights, European Convention of Human Rights rights. Interference with some rights is justifiable where it is, number one, necessary, number two, prescribed. In other words, it's permitted within the European Convention of Human Rights, or prescribed by law. It's been prescribed as unlawful in this country, and it's proportionate. Necessary, prescribed by law, and proportionate. The case at the Court of Appeal recognises that citizens should not have their human rights interfered with lightly. So let's establish, remember we're concentrating on auditors and people taking pictures in public. Simply taking a picture or video in public is a protected human right under Article 10, freedom of expression. Unless the photograph can be shown that they have committed an offence prescribed, which is another word for forbidden, and the interference is justified and proportionate, then if an officer in uniform has reason to believe the photographer has committed antisocial behaviour or is about to commit antisocial behaviour, then and only then can he require the person's name and address, but not the date of birth. Let's just wind that back a second and take it one step at a time because it is reasonably complicated. First of all, we need to establish, can the photographer be shown to have committed an offence that's prescribed? In most cases, no. It is not an offence to film in public because it's not prescribed by law. But not always. And as well as filming, you have to bear in mind that anything you do other than filming might be antisocial behaviour. For example, trespassing. For example, abusing members of the public or being aggressive with members of the public. Or possibly, I'm not saying that it is true, but because there's no case law on it that I'm aware of, filming registration numbers. But the act of filming in public is lawful, but there may be other acts connected to what the person filming is doing that could be not protected under the Human Rights Act, such as trespassing, causing a nuisance, a public nuisance by trespassing. On the example of the next slide, we have a police constable in uniform who has a reason to believe that a person's conduct has caused or is likely to cause harassment, alarm and distress to any person. He will have to, that is the police officer, will have to show his belief was reasonable. And so that's an objective standard. He will have to identify what conduct he says is antisocial behaviour. If the activity amounts to a protected activity, such as under the freedom of expression, the officer then will have to show that even if it was prescribed, the officer will need to show any interference with that activity was necessary, lawful and proportionate. It's the same in the courts. They have to interpret the law. On this example here, we have on one side of the scales human rights of individuals, and then there's human rights of others, the right to privacy, for example. What does the individual have to do to comply? Does the individual know potentially that they may be committing an act of antisocial behaviour? Would a reasonable person think it's an act of antisocial behaviour? Is the use of the power necessary and proportionate and reasonable? Against which is the courts will ask, has the prosecution satisfied a burden of proof? Is there a genuine act of antisocial behaviour? And who will have to measure sometimes a conflict between, say, the right of privacy and the freedom of expression. So there's a balancing act that the court has to do when interpreting law. In this example with this slide, I've given the balance towards the individual's rights, but that will depend on the facts. So we have a very powerful section under the Police Reform Act, section 50. How do I think it can be abused? Well, it has already been misused by the police to bully protesters and force them to provide their name and address before releasing them. Now, I'm referring to kettling, and there's some examples that are in the links at the end of the lecture with articles about this occurring and the police using this power to obtain intelligence about people who are being held in a group simply because they're protesting, having committed no crime. The courts have decided that some kettling for some period is lawful, but we don't know how long that would be. We don't know when that would be unlawful, and we don't know what the European Court of Human Rights would say about it. In my own opinion, if it went to the European Court of Human Rights, they may disagree with our courts. And they trump our courts still, because while we are a member of the Council of Europe, not the same as the European Union at all, separate organisation entirely. Another problem, it is ambiguous and easy for individuals to misunderstand because it's a spur of the moment power. It's not obvious what is and is not antisocial behaviour. That's another way of saying it. The case law, RV bonus, says at the Court of Appeal, pursuing a lawful activity is not antisocial behaviour. But it's what you're doing in addition to the public filming that the police may use to argue. If they simply are arguing on the fact you are filming in public and that is their sole basis to decide that you're guilty of antisocial behaviour, well, of course, the courts are bound to disagree under RV bonus. They need to show more than that. Even when it's misuse of police power and unlawful and unnecessary, if the person ordered to disperse or to give their name and address doesn't, they risk arrest and seizure of their property. So it's a high risk thing for you to do if some police officer quotes the Police Reform Act section 50 and says, I'm requiring name and address from you. Because if you refuse, you can be arrested. You can complain about it later, after your arrest, but that won't stop them arresting you. So it's your call whether you would supply your name and address. That's a matter for you to consider. I'm simply here to tell you of the risks. If we look here at Rowan Axon, who's playing the part of an inspector, we know he's an inspector because he's got what is called 2 PIPs, or Bathurst stars, which is their proper name. An inspector in the police has powers under section 35 of the Anti-social Behaviour, Crime and Policing Act 2014. Well, that's a mouthful. An inspector can authorise police in uniform and CSOs to require people to leave a specified area for up to 48 hours under Section 35 on the basis they have grounds that the officer must have reasonable grounds to suspect that the behaviour of the person they're ordering to leave, obviously, has contributed, is contributing, or is likely to contribute to members of the public in the locality being harassed, alarmed or distressed, or it's likely to contribute, etc., to an occurrence of crime and disorder, and that the direction is necessary to remove or reduce the likelihood of antisocial behaviour, crime and disorder. So we know the CSO and the police officer have to be in uniform. The power also extends to allowing that PC or CSO to seize anything which could be used for antisocial behaviour. Now, my concern is, could that extend to video cameras, filming? The power lasts for 48 hours, and anyone who does not heed the instruction to disperse from the area commits an offence and could be arrested. That's a big power for the police to have. It's a big power for the police to abuse. So let's look at some scenarios. Say you're a police auditor. You are attending a particular police station. Some members of staff get annoyed with you because you're filming them going to and from work. They complain to the police inspector, and the police inspector decides, I'm going to issue a dispersal order. Well, he's not going to announce it in the loudspeaker. He's going to tell people such as police officers and community support officers that he's issued a dispersal order, and he then will have to decide the area that it would apply. He will then have to justify the issue of the dispersal order, but he certainly has the authority to issue one, and one exists on his say-so. It says the officer must have reasonable grounds to suspect that the behaviour of the person has contributed or is contributing or is likely to contribute to members of the public being harassed, alarmed or distressed. Well, does that mean a member of the public, i.e. police civilian, who or canteen worker or whatever, who drives into work and parks in the police car park, couldn't be unreasonably alarmed or distressed because someone's filming? Possible. But how would a person who's the auditor, who's perfectly entitled to film in public, how would he or she know that they have caused harassment, alarm or distress, and that when they're acting within the law and within their protections under the freedom of expression? Well, the answer is it doesn't matter, because ultimately it says what the police officer the one authorising the dispersal order, thinks and does. It doesn't give the person who's subject to the order any power to refuse on the basis that it's unreasonable. They can argue with it afterwards, but if they argue with it at the time, then they risk arrest. And the only remedy they then have would be to argue their case at court and say it was a misuse of Section 35 after they'd been arrested, after they'd had their property seized, etc. And the courts may not agree because the definition is so wide. And the power of the inspector is so large. Just as an illustration on this slide, the only ranks in the police that can't issue it a dispersal order are the police, constable, and the police sergeant. Inspector, chief inspector, superintendent, chief superintendent, assistant chief constable, deputy chief constable, and chief constables all can issue dispersal orders under Section 35. Do I think this is ripe for abuse? Yes, I do. I've tried to think about what would be reasonable or unreasonable, and in relation to the issue of a dispersal order. I've illustrated by going on to a map of part of Liverpool, an area I know quite well. And I've done a small estate near Kirkdale Road in Liverpool, and I've marked that off with some highlighter. And it may be that an inspector would issue a dispersal order on the basis that two gangs have been fighting. Two gangs of youths have been fighting each other in the area, or a gang of youths on their own have been causing a lot of annoyance to residents. They've been smashing fences or knocking on the door and running away and annoying old people, or banging on doors, etc. The usual antics that youths causing annoyance may get up to. So in this particular circumstance, the dispersal order applies to a geographical area. So the inspector will have to specify to his constables and his CSOs where the dispersal order applies and where it does not apply. And they will have to tell people they're ordering to leave where they can go. Now, you can't use a dispersal order to order someone out of their own home if they reside there. So it's about removing people who don't normally live there. Stop people coming in to an area, or stop a group attacking a certain address or street within an area. A dispersal order covering a large area is less likely to be reasonable, necessary, or proportionate. because you're restricting the movements of lots of people over a very wide area. Now, I've illustrated this by doing quite a wide area with lots of people's homes included, and I've highlighted it. If some inspector or above decided to issue such a wide area, he'd still have to show at a later date, if it was challenged, that it was reasonable, necessary and proportionate. Where it can be abused, obviously I've given the example of police auditors, but also protests, demonstrations, protest camps, people who are picketing a particular area or protesting outside, say, a school, or protesting outside a youth centre or housing office, any particular premises. But it could also include places such as police stations or any place that the inspector defines as within the dispersal order. The legislation does not allow for automatic appeal. Your only way to appeal it at the time would be through judicial review or a complaint to a higher police authority, such as the police standards department or another organisation that monitors the police, and we've gone through those. Or after arrest, you would have to fight the offence or alleged offence and make a civil claim against police for false imprisonment and breach of your human rights. And of course, you're going to have to fight them to recover your property, because if they argue that it could be used in connection with the ASBO. So pretty frightening, isn't it? An inspector has not quite carte blanche, but a lot of power to issue a dispersal order on the basis of ASBOs or vague references to ASBOs, and the definition isn't tightly defined. The member of the public who thinks they're doing something lawful could be compelled to stop an awful activity such as filming in public on the basis of a police officer in uniform or a CSO in uniform telling them that an inspector in a local police station has issued a dispersal order. Of course, you can get access to the dispersal order. You can make an application under the Human Rights Act to see the order and what it covered and what it didn't cover, and why it was issued and why it wasn't issued, through making an application to make a freedom of information request. I've put forward some useful links. There's a lot of them here. I'll try and get them on the description. I know it's quite bleak, but I think it's important for people who take YouTube videos in the UK to be aware of these two powers, Section 50 power and the dispersal orders, because I think they are likely to be used more frequently, and they put some auditors at risk of arrest. Thanks for listening. Hope you enjoyed it. Take care and stay safe out there. Thanks for listening. Subscribe, please, to this channel, Law Rights and All That. We're on Facebook. You can like us. And we're also on the internet. Thanks for listening. Bye.